the case was a civil action brought for damages for mesothelioma caused by exposure to asbestos. The defendant was a company called Cape Asbestos, which was a company incorporated and with its head office in England, but it had a number of worldwide subsidiaries. Some of these subsidiaries were in South Africa where they mined asbestos. The particular subsidiary was in the United States, which bought the asbestos from the South Africans, took it to the United States, sold it in the USA, where it was used for the various purposes for which asbestos is used, and the people who worked in connection with these functions contracted mesothelioma. Some of them were very seriously affected by it, some of them died. Civil actions for damages were brought. But Cape Asbestos, the English head company, foreseeing the problems ahead, put into liquidation its South African subsidiaries, put into liquidation its American subsidiary, took all its assets out of America, so there were no Cape assets in America. So, but the action was brought by the Americans in a class action. There were some 20 plaintiffs, and they sued Cape Asbestos in America. And Cape took no part in that litigation. It deliberately abstained. It didn't make any submission to the jurisdiction, hoping that any judgment obtained against it would turn out not to be enforceable in England, which was the only place where it had any assets which could be used for the purposes of paying up on the judgment day. Now, in those days, I don't know whether the law is still the same in England. It probably is. If you have eventually the case went for trial in the federal court in Texas. It was quite a lengthy trial, as I say. Cape took no part, and damages. It was a class action. Some 20-odd plaintiffs' damages in millions were awarded against Cape. So then collection was necessary, enforcement was necessary. This judgment was worthless without enforcement, plainly. And the only place to enforce was in England. And in those days, maybe the same now, in order to enforce an American Texan judgment in England, you had to bring an action on the judgment in England. And a defense to that action could be that the foreign court had no jurisdiction. It could be that the judgment was affected by some defect in the observance of the rules of natural justice. Either of those defenses would suffice. Both were relied on in the litigation in front of me. Now, the complaint that there was no submission to the jurisdiction would have been a good defense, but there were some slight problems about that, although there had been no submission to the jurisdiction. And the interesting defense was the defense that the American procedure, the federal procedure in the great US of A, didn't comply with the rules of natural justice as they are understood in England, and that, if made good, was a good defense. And the particular complaint that was made was that the federal judge in Texas had not taken any evidence from any of the plaintiffs, but had looked at the list of 20 and had worked out sort of averages, and had then produced an average for all of them, multiplied it by 20, and that was the damages award that he found for the plaintiffs. And so that was the judgment that was being sued on in England. And those two defences, the jurisdiction, lack of jurisdiction, because Cape never took any part in the proceedings and had no residence in the USA. The only thing that was in the USA was the asbestos. And that came via some subsidiaries which were in liquidation. At any rate, I gave a judgment in favour of the defendant on both grounds. First of all, on the ground that there was no jurisdiction that would be recognised in England, and second, on the ground that the manner in which the quantum of the damages award had been reached was contrary to English ideas of how justice should be obtained in a case. There ought to have been some evidence from the plaintiffs, with medical evidence showing what their condition was and what the treatment that they might require or hospital fees they might incur would involve. None of that, there wasn't any of that evidence. The judge had simply, as it were, tossed a coin in the air and seen where it came down. And and therefore dismissed the action. But the reason I'm mentioning it is that it raised the 2 points that the Chairman mentioned in his opening, the importance of jurisdiction that's going to be recognised in the country where the assets are. In this case it was England, and there wasn't any such jurisdiction. And secondly, that anyway, even if there had been jurisdiction, the way in which the trial judge produced his damages award did not comply with the ordinary principles of justice that English courts would regard as essential to be observed if the judgment was to be enforceable. And Chairman, I thought it would be interesting for you to share my personal experience of that case, which does deal with, and I think answers some of the questions that you raised in your opening statement.
Thank you very much. A good example of theory and practice. Thank you.